Hi, this is Les with Metro Real Estate Group back to talk about paragraph 4, purchase price and terms. This is all about the money. So this is a big one, but we can get through it pretty quickly, I think. You just fill this form out. What's the purchase price? If they're asking 300 and you're going to put 300 in there, you put 300,000 right there. The earnest money is often close to 1%, so maybe it's $3,000 would go there, but it will say specifically in the listing agreement exactly how much they want for that. If there's private financing or seller financing, those would go in here. Your new loan, let's say in this example, would be $250,000 on a $300,000 offer. So you'd have to come up with $50,000. Your earnest money is $3,000, so cash at closing, this will automatically fill in and say $47,000. So both sides will come to the $300,000. So those will all need to balance there. If the seller is going to give a deal to the buyer that by a certain amount, this will go in here. Maybe it needs a new roof and the seller is not in any position to get that done. Their insurance isn't going to cover it, but they recognize it needs to be done. Maybe they'll put, a certain amount in there based on their estimates to cover, and it can go for anything. It says buyer's closing costs, discount points, origination fees, other expenses or expenditures. So just about anything can go in there. Notice this red thing. You may have seen this flash by. This will not be active until January 1st. I'm recording this in early November. So much of this is the same as you'll find in 2018, but what we're going through is the one that will be effective in January of 2019. So the earnest money is generally in form of a personal check. You can put a money order there if you want to, and then it will be payable and held by, it's often the title company that's the earnest money holder. Again, that will be clarified in the listing agreement. It may be the real estate brokerage, somebody who's got a trust account and can put that in. If you aren't putting it in at the same time as the contract, you'll need to get it in by the alternative earnest money deadline, which we talked about a little earlier. And so that's covered there. The return of earnest money, if the buyer has a right to terminate and terminates on time, and there's lots of reasons they can get out, then the earnest money is returned. Within 3 days of the seller getting a form that says we want our earnest money back because we didn't like the loan, we didn't like the appraisal, we didn't like the inspection. There's several ways they can get out. If they do, or if you do as a buyer, within 3 days you should get that money back. Form of funds, this is good funds. This means you can't give them another promissory note for your down payment or anything. It's got to be cash or certified check or funds wired in. Generally, the title company will tell you how they want that done. Some of them are not taking certified checks anymore because of fraud. So they're working with wires, and there's lots of warnings about wiring money in that you will be alerted to in plenty of time. Time of payment just means it's got to all be done at closing or before. Otherwise, anybody who doesn't come up, it will be in default. And this is very critical. The buyer represents that the buyer, as of this date of this contract, does or does not have funds that are immediately verifiable. So if you've got $47,000 down as your cash at closing, you would put he does have funds that are immediately verifiable. In other words, you've got it in a bank account that you can show that it's really there. Otherwise, you would click does not, and that may make the seller not want to lend to you right away or sell to you. So it's a good idea to have that money available, obviously. Also, in the earnest money, I forgot to tell you, don't just write a check assuming they're just going to hold it until closing. They will put it in a trust account, and it will be cleared just like a regular check. So if it's a $3,000 check, make sure that account has $3,000 in it because it'll be cashed and put in their account. Then you'll get it credited at closing or returned if the closing doesn't happen. New loan. So if you're buying, you will be responsible for paying all the loan costs. You get to pick whoever you want for financing, and you can choose who you're going to get for your lender. So most of you will pick conventional. If you're a veteran, you may go for a VA loan. If you qualify, you may get for a FHA loan. And if any of these others apply, you will be in contact with your agent and your attorney to deal with those. The loan estimate will tell you exactly how much will be included in your principal and interest, and then you'll also want to know how much you're going to be paying for your taxes and insurance, so you get a total picture of how much money is going to come out of your pocket every month. Assumption, this is a big section here. This is unusual, but sometimes a buyer will assume an existing loan. So the buyer has, or the seller has, a loan to buy their house, and it's from a bank that allows an assumption. They may say, just take over my loan. Most major banks will not allow that, so this will not come up. If it does, again, consult with your attorney. Then seller private financing. If the seller is going to lend you some money as opposed to letting you take over or just having you get your own loan, all this is important here. Contract provisions, unless exempt, should be prepared by a licensed Colorado attorney or a licensed mortgage loan originator. You or I or another broker cannot write up that. It's got to be a licensed mortgage loan originator, which would include an attorney in this case. It says brokers should not prepare or advise the parties on specifics of financing, including whether or not a party is exempt from the law. So I can't advise you on that, nor can anybody else who's not a real estate attorney. If the seller financing is included either the seller financing or the buyer or the seller will deliver the financing documents to the other party on or before this many days before the deadline. The seller can terminate if they decide that based on what they've seen from you, your credit scores and reports and all that kind of stuff, they might not feel comfortable, and they can get out before the seller or private financing deadline. If you're the buyer, you can get out the same sort of way on or before the seller or private financing deadline. If you determine that this just isn't going to work out for you, you can get out there and get your money back, your earnest money. So that's it for this one. Then we get into the transaction provisions next.